we'll switch now to Grant Morris. Grant is an associate professor in law at Victoria University in Wellington, an accredited mediator, has worked as a facilitator and negotiator over the past 2 decades. His research areas include mediation, interest-based negotiation, and New Zealand's legal history. And he has also got involved over the past couple of months in the legal ramifications and implications of COVID-19 and the government's responses. He's also one of the COVID Plan B member groups. And over to you now to Grant to have with your presentation.
Cool, tēnā koutou, and thanks, Mark. Can you hear me okay?
Yes, we can. Go for it.
Right, I'll just share my screen now as well. Can you see that okay, Mark, with the PowerPoint slides?
Yes, we can. It's up.
Thank you. And today, as Mark said, I'll be talking a little bit about the legal ramifications of the COVID crisis. And as many of you will be aware, the Plan B group was set up as a multidisciplinary group led by public health experts such as Simon. But the idea was to come at this problem from a number of different perspectives, including law, economics, and other key areas. And while this is fundamentally a health crisis and a health issue, there's a lot of other things going in together. And we would argue as a group that they are interlinked. So you can't deal with one in isolation, but rather you need to deal with them as an overall response. And we've heard that today already from some of our speakers, where it's not lives versus the economy, it's not lives being separate from the economy, but rather an holistic perspective. So what I want to do today is just talk about some of the law related to COVID, and in particular, some of the legal issues that have arisen, and also in particular, those relating to civil liberties, and how that plays out in a New Zealand context. I started my journey with the Plan B group fairly early on in the crisis. So a week after lockdown, I wrote a piece for Radio New Zealand, asking questions about whether the government was approaching this in the best way in terms of getting compliance and support from the public, and whether there were other ways rather than focusing on fear and legal sanctions, other ways of getting the cooperation and necessary reaction from the public. And I'll talk about that later on today. So let's start with some of the legal frameworks for setting up the COVID regime. So basically, the government was relying on 3 acts: the Health Act 1956, the Civil Defence Emergency Management Act 2002, and the Epidemic Preparedness Act 2006. So those were the 3 acts which formed the foundation for the first lockdown in late March. Now, as has been shown, these acts had gaps, and they were not really fit for purpose in terms of dealing with this particular crisis. And we saw in particular during the first 2 weeks of the crisis that there was a lot of confusion. Could you go to the beach? Who was allowed to open? Butchers versus supermarkets. You know, what sort of exercise could you do? What were the rights and the protections on the citizens? What were the powers that were given to police? So there was a lot of confusion. And then when the subsequent Section 17 notice came in under the Health Act 1956, that clarified some of it, but there's continued to be legal questions around what was actually allowed, and also the legal robustness of the government's response. Because of that, we had recently Parliament passed the COVID-19 Public Health Response Act 2020. And this is really an attempt to fill those gaps and to make sure that for subsequent lockdowns, like the one we currently have, there would be a more firm footing for the government's actions. So Plan B was able to make a submission to the Public Health Response Act, which I authored and presented orally at the select committee. And there are some major issues with the Act, but it has to be said that it is more comprehensive than the other three. So the other three are still in the statute books and still supplement the specific COVID legislation. But we did need that specific act to clear up some of those problems. But that's only in the area of statute law, because we also have, of course, case law or common law going through the courts, and you'll be aware of two cases in particular that came up in the courts and received a lot of publicity. And the first one is Christensen and Director General of Health in May 2020. So both of these cases are judicial review cases. So that means that the applicant is basically saying that the government has not followed the correct process, and the High Court of New Zealand has to make a decision as to whether the executive has indeed acted outside the boundaries of the law or not. So in the first one, it was quite specific in the sense that it was the son whose father was dying, and he was looking for an exemption to be able to leave quarantine to visit his father. And of course, there'd been this blanket ban basically on those exemptions, but this applicant successfully applied to the High Court to get that reviewed, basically on the basis that the legislation, the Act provided for these exemptions, and when it was reasonable, they should be considered and granted. And so that was a success in terms of judicial review. Remembering it's focusing on the process, so rather than the substance per se. The more wide-ranging and high-profile case, though, has been the Borrowdale case, which has recently been heard by a full bench of the High Court. So that's Borrowdale and Director General of Health in July 2020. And this case, brought by Andrew Borrowdale, who's a former law academic and legal draftsman, tests the overall legality of the first lockdown. So all those gaps I was talking about before and confusion. Was the government acting under the law? That's the big question. We were all hoping that someone would take this case and wondering who might be the best person to take it. Andrew Borrowdale has received support in taking the case. The court has received advice also from organisations like the New Zealand Law Society. It's a very important case, but it has to be said that any result from the case is largely going to be retrospective in the sense of telling us what happened rather than what is the state of play now, because a lot of that confusion has been cleared up by the subsequent act. But that's still important. From a legal point of view, we need to know that the government is acting under law and that New Zealand operates under the rule of law, and that even if the event has passed, what was the situation, and to make sure that if it happens again, things are done more effectively. Also, of course, there were a number of convictions under that first lockdown, and there will be ramifications, one would imagine, for those should the applicant be successful in that case. So there's a lot going on here in law, and my colleagues in the Legal Academy have spent quite some time debating this in public and providing seminars, and some of it is very exciting and very interesting, some of it's quite dry, but it's all important and it all intersects into the health debate as well. As I've noted with our multidisciplinary approach. I want to talk now about some of the civil liberties. My particular focus has been on civil liberties and how these have been affected by the lockdowns and the COVID crisis in New Zealand. So I just want to spend a bit of time on those because like other areas of the COVID crisis, I think there is some confusion out there in the public as to what the real state of play is. Firstly, we must note that our civil liberties as New Zealanders come from a range of different sources. They come from statute law, they come from common law. They reach back centuries. They reach back into the history of course, England and Britain, where we inherited our law from as of 1840. We can find those protections in Magna Carta, in the Bill of Rights 1688, which we incorporated into or inherited into our legal system in 1840. And more recently, we can find them manifested in our New Zealand Bill of Rights Act 1990. We can find them in famous cases like Inter King Carrington from the 18th century. the New Zealand Bill of Rights Act 1990 didn't necessarily create anything new. It really confirmed what was already in existence in other law, statutes, common law, and brought that through in one specific act. And as many of you will be aware, there are weaknesses to our Bill of Rights in New Zealand, our 1990s Bill of Rights. It is not supreme law. It is not entrenched. And if it comes into conflict with other law, it doesn't overturn or override that law, but rather the other law could potentially override the Bill of Rights. So it is not like the US Bill of Rights. It is one which the judiciary has shown strong support for, and one would say perhaps breathed life into, but in terms of its legal power, it is much weaker than I think many New Zealanders think. But I want to pick up on three rights that are in our Bill of Rights and in the other law that I've alluded to, and how they've been affected by the COVID crisis. So let's start with freedom of expression, because I think this is a particularly important one in terms of what we're talking about today, because we are today exercising our freedom of expression under Section 14 of the New Zealand Bill of Rights Act. And that's vital. It's also vital for the six of us who founded the Plan B group, because we're all academics, and therefore we all have protections under Section 162 of the Education Act 1989 to be able to publicly air our views based on our research in our particular areas. And indeed, we have an obligation to do so. It is our duty to contribute to the debate, and that's the same with the academics that you've seen more of in the news than us. That is their obligation and right as well. So there's that aspect of it. And then also there's the aspect of balanced debate. And it's really a story for another time, but as a group, we have struggled, it must be said, to get an opportunity to air our views. We have had the opportunity to do so, of course, evidenced by news reports and so on, but that has been relatively limited, and also must be said that our views have not necessarily been accurately portrayed. And that has been a problem. The debate has been limited, I would say, in terms of the way in which coverage has been provided. The second right I want to talk about is freedom of movement. Now, this is one that obviously has been curtailed by lockdowns and by the closed borders. So this is not to say that these rights are absolute. In fact, they're not. They can have reasonable limitations placed on them under our Bill of Rights, and many would argue that is what is occurring now. But the lockdown obviously has huge impacts on freedom of movement, and of course closed borders do as well. Our ability to be able to move to and from our country and to get back into our country, and what will happen when we do through quarantine. So Section 18 is one that has been heavily affected by the lockdown. Section 21 is one also that I want to touch on, and that is unreasonable search and seizure. So here we get into the whole issue of due process. And in particular, what are the rights of the police to enter your property, to check that there's not a gathering which is too large or that is breaching the Section 17 notice or the guidelines under level 3 and level 4. Now, our rights to protect our private property and to prevent others coming onto our private property stem all the way back into our law. They don't flow just from our New Zealand Bill of Rights Act. They go back to ancient, fundamental rights. And so therefore, when they are curtailed under law, whether it's the original lockdown laws or whether it's the more recent Public Health Response Act, these are serious issues. Now, again, the government can do this. The law stands. Parliament is supreme. But when it chooses to curtail those rights, it's absolutely vital to have an open public debate on them. And we saw that increase, we saw that improve once we got out of level 3 and we got to level 2. And here, you can see much more robust public debate occurring around these issues. So we got there eventually in terms of having that debate, but it took some time. There's a lot of issues flowing from those rights. As I said, they're not absolute. The way our Bill of Rights works is a very confusing interplay between sections 4, 5, and 6 as to the extent of the rights and when they can be curtailed and what can be reasonable limitations. And when we have this discussion, we're also having a discussion about the three fundamental concepts in our constitutional system: parliamentary supremacy, separation of powers, and the rule of law in New Zealand. Parliament is supreme in New Zealand, so it makes the laws that it chooses to make. And we've seen that. We've seen that with COVID-19 and the Public Health Response Act and the other law that we've talked about today. And Parliament will continue to make law in response to this crisis, as is its right under our Bill of Rights 1688 and other legislation, Constitution Act 1986. But due to our rather ineffective separation of powers in New Zealand, where we effectively have an overlap between our executive and our legislature, that is, if the government has the numbers in Parliament, which it does by definition of being the government, then it can push through legislation and will be sure of doing so if it has those numbers. And so therefore Parliament and the executive have a strong overlap. And what are the checks and balances on that? So there are issues around that. And for me, the most important issue from a civil libertarian point of view is that idea of rule of law. We have to be operating under the rule of law. And so what the government does in this space, whether it's about movement or freedom of expression or search and seizure and warrants, is absolutely pivotal, and we need to have the debates. And just picking up on two issues which I've seen have come up through the chat today, and that is relating to masks and, if they are to be made compulsory, and it looks like we might be heading that way, can we do so under existing law, or will Parliament be needed to make new law? Parliament looks like it's coming back tomorrow as the election is delayed. And that is a question that the government currently has its legal experts examining. But Parliament can make new law to do that if it so chooses and if it has the numbers and the time to be able to pass that law. And we've seen much of this has been done under urgency, so the legislative process is sped up, and select committee is often missed out, and that has issues of itself in terms of democracy. But again, Parliament can put itself into urgency. And then another issue which I've seen come up through the chat today is the vaccine. Well, if there will be a vaccine, will that vaccine be mandatory? Will it be compulsory? And how do you make a vaccine compulsory? And what about rights under the Bill of Rights, Section 11, in terms of the right to refuse to undergo medical treatment? What will occur there? We know vaccinations are a vexed issue in New Zealand, and that we've had a real struggle to be able to get high levels of vaccinations for MRI and other vaccines. And that I imagine that debate will continue. Also, we need to look at issues such as international law, and I think this is another area where there is some confusion in New Zealand, where some people will look at international conventions and say, well, look, that's what United Nations said, then New Zealand should be doing it as well. Wherein the situation legally in New Zealand is that we enter into international conventions and then we take the next step of bringing those into our domestic legislation. And when they're brought into our domestic legislation, then they can be enforceable in our legal system. So it's not a simple matter of just looking at, see what the UN's done, but rather what is the way in which they have manifested themselves in New Zealand. Okay, so just to conclude, I think I have my coming up to 20 minutes now. I just want to finish with the, I suppose, the overall thesis that I've been working on and first aired in late March, and continue to argue, and that the approach that this government and many governments have taken around the world is to achieve societal compliance through fear, through making people worried and fearful about COVID. The line of pretend you've got COVID, pretend everyone else has got COVID, is not the only way. It is one way, but it's not the only way. There is another approach which is more consistent with the social contract in a liberal democracy. And I believe that that approach is one which is based on education, open debate, so hearing from all perspectives like we're doing today, and a certain level of trust in the population as well. A trust that the population can and will make rational choices without the need for fear, without the need or threat of legal sanction, but rather trusting your population. And you know, some people trust the average citizen and some don't, but I believe we should. And I believe that is the most effective way to achieve a long-lasting and effective outcome for this particular crisis. Thank you.
Thank you. Right, we've got a couple of minutes for a couple of questions. Thank you, Grant, also for answering a lot of those in your presentation. Just looking at a bunch that are coming up now. A lot of them are just to cover some of the same ground you already have, if you don't mind. People are asking, how is it that the government can do a lot of these things without necessarily either having the evidence or having sufficient public input? I think your answer is, yeah, Parliament reigns supreme, it can do whatever it wants. But is anything able to be questioned if it can't be justified?
Sure. So I suppose we've got two issues here. One is the fact that Parliament is supreme and its law stands as the law of the land. But then you've got the actions of the executive as well, so the actions of government. So that's what we see in the Christensen decision. That's what we see in the Borrowdale application as well, is judicial review. So we can use our third branch of government, the judiciary, to be able to challenge the actions of the government. And that's why the Borrowdale case is so important, because that needed to happen. Someone needed to challenge the decision-making and the process of decision-making of the government. So, you know, judicial review was and remains the most effective legal route to challenge what has happened. Beyond that, it's through what we're doing now. It's through open debate with the community and airing our views. That's why the fourth estate is so important as well, because they allow us to be able to air our views beyond just our close circle, but rather to, you know, tens of thousands, hundreds of thousands of New Zealanders. And so the media's role in this, in terms of supporting a liberal democracy, is absolutely vital. And they're in a very powerful position at the moment.
All right, to be specific, with some of the things that are coming up, you know, we've had questions over the past couple of months around laws that were introduced, and we're still going. There's more plans. There's possibly more lockdowns, possibly regional. There's a suggestion, or at least a response to questions from the government over the weekend, that they could try to make masks compulsory. There's been a few questions up here today around making vaccinations compulsory. If I get this right from what you're saying, the government could pass those laws. It has a couple of days now left in the parliamentary session to do it, and it could do it quickly, and it could do it without necessarily the evidence.
Yeah, so again, you know, I think those are two you know, vital issues. Masks, I think, is probably the more current one, given that we don't have a vaccine yet. And with masks, yeah, if Parliament needs to, if they feel that the existing law is not there, I think they're pretty confident they can do it under existing law, but if it's not there, then they will pass it. In terms of vaccine, that I think is going to be a far more controversial one, and I think I've mistakenly said MMR, right? I mean, MMR vaccination, you know, that's been such a big debate in New Zealand. But to be effective, it may well be that it needs to be mandatory, that it needs to be compulsory. And how do you do that? And again, how does the Bill of Rights operate in that situation? We have a right under the Bill of Rights, but then the Bill of Rights is limited. So the government, if it creates specific legislation, then it can well override that right.
Two more questions quickly. So the Director General, if I think you're referring to the law where the Director General can make such, he could probably impose a mask, a requirement for masks, but he has to provide an assessment for the risk to public health.
That's what.
Sorry. Yep.
Yeah, that's what the government's currently investigating in terms of what is the most legally effective way that it can make masks compulsory. And as my understanding is, it doesn't have a fixed answer yet. We're yet to hear under which law it will actually do so. It's quite complicated. Otherwise, we would have heard more of it by now. Yeah.
Yeah. And a wider question. What we've struck here is a problem for timing in response to emergencies, in terms of making law, government acting in a democracy. It has the power to do so, perhaps that is the answer, but it seems profoundly uncomfortable to a lot of people that it can act so quickly, and perhaps incorrectly. But that seems to be the challenge. How does it, in a democracy, how do you act quickly to an emergency if you can't do this?
Yeah, and it was, as I mentioned before, urgency has been used a lot in terms of being able to fast track legislation through Parliament. But the reality is that in a liberal majoritarian democracy, it is hard to move that quickly, and so the government's got this tension of needing to control an emergency, but also bringing the country with it and doing so in a way that has buy-in and has gone through the necessary kind of quality control, and it's a very tough situation. And so all we can, I suppose, advocate for is for as much public involvement and debate as is possible.
All right, thank you very much. I think we've covered a lot of what's been up there in the questions, but if you are hanging around with us for a bit longer, Grant, there are probably some that you could address if you can in written form.
Sure.
Okay. Thank you, Grant. Thank you very much.